In an action to recover damages for personal injuries, the plaintiff appeals from a judgment of the Supreme Court, Suffolk County, entered October 16, 2000, which, upon a jury verdict and upon the denial of the plaintiff's motion to set aside the verdict as against the weight of the evidence, is in favor of the defendants and against him dismissing the complaint. In this case, we find that the motion is meaningless. The plaintiff was injured when the motorcycle he was operating collided with a pickup truck operated by the defendant at the intersection of Bailey Road and Kerr Road in Middle Island. At the time of the accident, the vehicle operated by Collins was proceeding westbound on Bailey Road, which was controlled by a stop sign at the intersection of Curry Road. The plaintiff's vehicle, which was proceeding westbound on Curry Road, a through road, struck the Collins automobile on the passenger side in the middle of the intersection. Collins testified that he stopped at the stop sign approximately 15 feet from the intersection and that upon looking to his right, his view of Curry Road was obscured by woods. Collins then stated that he did not see the car coming. Not observing any approaching traffic, he looked forward and was immediately struck on the right by the plaintiff. He testified that he never saw the plaintiff prior to the impact. The jury returned a verdict finding Collins not negligent. The trial courts subsequently denied the plaintiff's motion to set aside the verdict. The trial court applied an indirect standard in considering the plaintiff's motion, and the verdict was not set aside. In this case, the proceeding into the intersection without yielding the right-of-way to the plaintiff, such violations constitute negligence as a matter of law, and therefore the matter could not have been disregarded by the jury. In this case, the plaintiff may have contributed to the accident by exceeding the speed limit and proceeding in the wrong lane. Moreover, Collins was obligated to see that which by the proper use of his senses he should have seen. And the plaintiff, as the driver with the right-of-way, was entitled to anticipate that Collins would obey traffic once he turned into the intersection, and that was to be expected. However, the plaintiff is not entitled to judgment as a matter of law in the favor of anyone in this case because it violated the due rules of the road. Since there will be a new trial, we note that under the facts adduced, the plaintiff was without or was entitled to a jury charge in the emergency doctrine, and the emergency doctrine is applicable when a party is entrusted by a sudden and unforeseen occurrence that is not of his own making. In this case, 726 New York Supplement, 2nd, 334, 750 Northeastern 2nd, 36, Herbert versus Margaret Driver, 742 New York Supplement, 2nd, 3. Current and or former drivers brought actions against companies that operated radio dispatched limousine service, alleging breach of terms of parties' franchise agreements and violations of labor law.